To my left, your right, Judge Matt Wilson from Jackson, Madison County. To my right, your left, Judge John Campbell from Shelby County, Memphis. I'm Robert Holloway. I'm from Murray County, Columbia. As most of you probably know, each side will have 20 minutes to argue. If the appellant would like some time for rebuttal, if you would let us know at the first of your argument how much time you would like to reserve. We have read the briefs. Normally we have not read the record at this time. Any preliminary matters?
No, Your Honor.
Anything before we call the first case? All right, call the first case, please.
Richard Crawford versus State of Tennessee.
Mr. Tootin.
Good morning.
Morning.
May it please the court, I'm Attorney Terrell Tootin on behalf of the appellant. I would request 3 minutes rebuttal. This matter involves Richard Crawford, the defendant on this case, who had convictions of especially aggravated robbery, 2 counts of aggravated kidnapping, attempted second-degree murder, employment of firearm during the commission of a dangerous felony. And I recap that just to highlight that although every criminal case is important and serious, that these charges are especially serious and that it's extremely important that we get the law and the facts right when determining someone's fate, because the amount of charges he was convicted of and the seriousness and the punishment in which they carry is not something that can be easily overlooked. The first issue that I'd like to highlight, I understand you've read the briefs, but I think the issue that almost is the end-all to this matter, meaning if you agree with me on this issue, there's probably not much else to talk about, and that's that in this case, there was testimony provided to the wrong crime or the wrong incident. I don't know if it can be any more flagrant or get much more serious than that. The alleged victims in this matter were husband and wife. The victim, Abdel Murphic, who was going by the name Mike Murphic improperly during the trial, said that basically him and his wife were robbed at gunpoint by the defendant, but there was testimony regarding an October incident. The incident that was supposed to have been testified to was from December 7th of 2009. The reason that is important, well, for obvious reasons it's important, but what makes it even more significantly important is that this had previously happened where the wrong information was presented to the trial court, meaning they addressed the crime they weren't supposed to, and the judge declared a mistrial. That's how serious the violation was. And so we now have a framework of how the trial court saw this issue. A lot of times you all have the duty to try to fill in the blanks or try to review something de novo or just try to, from where you're sitting, try to see if you can recreate what happened to try to reach a conclusion. Here we already know the framework. The framework is this is a serious violation. Do not make this mistake. If you do, the remedy is a mistrial because it's that significant of a mistake. So when it happened in this conviction, nothing happened. Trial counsel did not catch it to make that position in that time, is my understanding from the record. And there was no request for a mistrial. We know a mistrial would have been granted because we know that that is in fact the remedy that the trial court had set, and it was allowed to go forward. The wife mainly corroborated Mr. Murphy's testimony. So at this point, we have a very significant problem as far as what information the jury is receiving and what they're hearing. For that to have occurred, I don't see any way legally around that being an error of such a nature that means that trial counsel was deficient, but also to the defendant's detriment because it led to a conviction. I don't know if there's any gray area or wiggle room left available when that level of mistake is made. So I think that issue, if we didn't talk about anything else, that issue alone was sufficient to warrant a reversal of what has occurred. The other concern that I'd like to highlight is that it appears that the defendant had evidence that Abdul Murphy, who was again going by the name Mike Murphy, and let me talk about that briefly. I think it was highly significant that the name Mike Murphy was affiliated to, I believe, the alleged victim's father, and that it appears that that name had been used in order to purchase property improperly and things of that nature. I think that's important. That was referenced at the post-conviction hearing. The post-conviction judge didn't understand how it was relevant. In essence, the argument is, well, if we're talking about these crimes on this day, who cares if he's committed fraud under this other name? I respectfully disagree. I think it's highly important for jurors to know what type of person they're dealing with, and the credibility of a witness is a centerpiece to every case, specifically a material witness. So it is not something that should have been swept away or ignored when you have evidence that this person is engaging and willing to engage in fraudulent behavior, especially if you're taking that person and having to trust what they are telling the jury as far as facts of the case. But then circling back to the bribery issue, it also appears that this same individual with his wife has attempted to bribe police officers, and that police officers were going to be willing to testify and were not allowed to testify. So not only were they not allowed to come into court, if nothing else, to make a record on appeal so that we can have the record or some type of proffer, in addition to that, they just weren't allowed to testify at all. Now,
Mr. Chief, let me just ask you a question, just because maybe I'm a little confused about this. You're saying the lawyer should have impeached the witnesses that an allegation that they bribed police officers.
Correct.
All right. Now, under the rule, if they had said, no, we never did, you're stuck with their answer because they were never charged or convicted with bribery. Is that correct?
No. And here's where I disagree slightly. If they were to give an answer and said, no, this never happened, don't know what they're talking about, I believe, and again, you will correct me if I'm wrong, that you're then able to call the officers to the stand to then testify to rebut that representation and then allow the jurors to make an ultimate determination.
I don't think the rule allows you to bring in extrinsic evidence on something that is not a criminal act. I mean, a conviction. I mean, if you deny a conviction, you can bring in proof that you were convicted. But if you were never convicted or charged, you're stuck with the answer. And apparently these people denied, if I understand the record clearly, they denied that they bribed police officers. And
again, and that's where I'm assuming your ruling will disagree with me on that. My only contention is that once someone denies it, our position is no one is allowed to get on the court, on the stand under oath and say things that aren't true. And when they say something that you rebut, then is our position that we believe the rules allow you to then take it on someone else to testify to impeach that testimony, because it's not always a crime that someone gets impeached with. Someone can say something and then you have someone get on the stand and say the opposite to impeach what they're saying. We believe.
What did the trial judge say? I'm sorry.
My question on that is, which rule allows the extrinsic evidence?
So I think a statement against interest, I think once you have opened the door to saying something, like, because you're testifying under oath, I don't believe anyone is questioned, it has to be accurate. Once you say something that is challenged as accurate, I think you put on rebuttal. And I know that, let me say this, the way we routinely do it, and I think the way we routinely see it, which might be is easier way to talk about it, is you have a witness testify about some facts that happened on a case. And they say, I never said there were 3 people, I said it was 2. The defendant then gets an officer on our case. We put on an officer who says, based on my police report, they told me it was 1 to 2 people.
Well, that would be a prior inconsistent statement.
Yeah, but
So, also found in the rules of impeachment, which rule under the 600 rules allows the scenario you're referring to?
so I don't know if it's 608, but I think the way we've normally done it is just to impeach a witness. I don't know if there's a specific rule that talks about impeachment. I know as far as once someone testified, my position and our understanding is once you have testified under oath and there's a question as to whether you were truthful, my understanding is we then open the door, but I don't know if there's a rule that specifically says that. I don't believe I've ever quoted a rule we've just put on the witness. Just so to be honest, I don't believe I've ever cited to a rule. Is simply once they've opened the door by testifying under oath, and our position is, well, that testimony is not true, the defense has a constitutional right to say, our theory is that they're lying. Our theory of the case is what they said isn't true, and our theory of the case is you can't trust them. Because I don't think it's disputed. If there's one thing I hope we all agree on is that the defense has a right to put on the defense, and that the defense can be what the defendant's theory of the case is. And the way I've always presented it is, under our theory of the case is, we can say you can't trust this person because A, they're lying about their name, B, they've lied about their name in order to get property because they don't mind who they defraud as long as it's to their benefit. And then C, you can't even trust what they say because they're known to bribe people, including police officers. They have no limits. That would be just exclusive to the defense of the case, separate and apart from anything else. And I believe that's how I've routinely done it. I believe that's what the law allows. But I would agree with you. I'm not sure if there's a specific rule that talks about that. This would be more so of a defendant having a right to put on a defense, and that defense being, you cannot trust this person is not credible, and here are the reasons why. That's how I would understand it. And so I think that was important. Now again, the post-conviction court seemed to take the position of, what does that conduct, any of the conduct I named, have to do with this particular incident? And so we think that misses the mark. We don't think the standard is limiting to that incident. As I said, we think the standard is the defense is allowed to show his innocence, because if he's not able to put on that defense, what happens is the jury is encouraged to receive a false narrative where you have a person that is being appeared to be honest and trustworthy with no information to the contrary. And so that is the concern that happens if you're not allowed to put that evidence on. And at a minimum, if the witnesses were there at the hearing, there's no reason that I can see or where the law says you can't at least allow them to do the offer of proof to make the record clear. So at a minimum, I believe it would have to come back, if nothing else, for those issues. But those are things that I think are imperative. In addition to that, the fact that Abdul Murfiq had a federal conviction that wasn't explored. From the record, it appears as if either the trial counsel did not realize it or maybe knew at one point and forgot. It is unclear when trial counsel got that information. It appears at some point he did have that information, but at some point he also didn't have it, and he seemed to suggest that he would have used it if he had it.
What did Mr. Murfiq testify to at the post-conviction relief hearing?
As far as what?
As far as this different name, bribing police, prior federal conviction, and those types of things.
Okay, so my understanding is there's no testimony of him saying it happened. Now, the name he acknowledges, and I recall him acknowledging his name, and he said his name was Abdul Mike Murphy. Like there was a long extended name, and basically part of the name, Mike Murphy, was included in the name. And so his position is, oh, that's my name, and that's what I go by. The federal conviction was under not the name Mike Murphy, but under Abdul Murphy, I believe, which is why defense had trouble retrieving it, locating it, seeing it. Again, I don't want to misrepresent anything. It appears at some point trial counsel didn't have it and said I would have used it if I had it. And then at some point he seemed to say that he knew about it. So what I have to glean from that is that this may not have been an error where the state didn't provide it or did not provide enough information for it to be retrieved, as much as it may have been ineffective counsel. So in other words, I would be up here arguing that the state withheld it if the record was cleaner to say that they withheld it, but based on trial counsel's statements, he seemed to suggest that at some point between the first trial and the second trial, at a minimum, he had it by the time he was able to cross-examine, or at least had enough information to be made aware of it. It just may have slipped through the cracks. And again, this goes towards the credibility of a vital immaterial witness. But just to put a bow on it and circle back, Mr. Murphy essentially said, that is really my name. or at least part of my name that I go by. Therefore, there's nothing wrong with me using the name in that way.
Well, his wife said that she knew him as Mike Murphy.
Yes.
But according to the social security card he had, is Abdul
Yes.
Aziz Mike
Yeah.
Murphy.
That's the full name. Yeah.
So, I mean, it's kind of a stretch to say that he had a false name, he was defrauding people.
Well, here's why it's not a stretch. Respectfully disagree. Is because in this case, what occurred is that when we talked about the fraud specifically, because there's one issue about not locating the federal charge or using it due to a confusion with the name, and again, I believe that falls more on trial counsel than the state. As much as I enjoy arguing about what the state did wrong, I don't know if I can say that in this scenario when it appears that trial counsel is saying I had enough clues to be aware. So that was a trial counsel issue. But the defraud issue goes to if what they were not able to get into fully on the post-conviction court, and the judge basically said, okay, maybe I agree with you, but who cares? In essence, clearly paraphrasing, that wasn't a direct quote. But basically what happened was it appears that he got property under the name and under the identification of his father, even while his father was deceased, and he used the name similarities to basically defraud to make that property transaction occur. The post-conviction court basically said, okay, we're in left field, why is that relevant? Whereas our contention is that's absolutely relevant. It's telling you the type of person we're dealing with and what they're capable of and where their limits are or where their limits are not. And so that's why we think it should have been able to be presented, because at trial, again, that goes to the theory of the defense. Although we can see that's not an issue directly related with a crime that night, but it's 100% related to, can we trust you? And the fact that the property may have been purchased, it looks like, with him and his wife, or they both were aware of it or engaged in it and both benefited from it, that goes to the credibility of both parties. So again, it's not a ringing endorsement when she says anything that validates or vouches for what he said, because our position is you can't trust either one of them, especially when their testimony seems to track harmoniously together and that they're basically unbreakable in what they're going to say and testify to, and that they both have serious character flaws that goes towards their credibility. The concern is, how in the world is the defendant not able to explore that when his life is on the line to tell the jury, these people saying these things about me have tremendous credibility and character flaws, and here they are, and here are the reasons you can't trust them. For those things not to even be allowed to say it out loud, I think, is a travesty, and it gives the justice system a black eye, quite frankly.
Well, and I think going back to what Judge Wilson asked is, in order to show prejudice, you'd have to show that this would be admissible under some recognized legal theory.
Yeah, it would be the defense.
What would it be?
It would be the defendant's theory of the case, which they're entitled to put on the defense.
Just because you have a theory doesn't mean you're going to get your proof in. It has to be a theory. It has to be something that the rules of evidence allow you to submit. I'll let you answer this real
Okay.
quick.
I think, and again,
What rule would allow you to get into this extraneous information?
I think any time you put on the defense, you're allowed to talk about why there are credibility issues. So it would be impeachment of a witness, basically. And I understand you're impeaching the witness credibility, and you're talking about the witness's character and their character traits and their tendencies to not be truthful. Character traits you're allowed to get in under the rules. Impeachment of a witness you're allowed to get into, I think, under either scenario, whether you're talking about character traits or impeachment, it's fair game when you're putting on your defense. All right. Thank you.
Good morning, Your Honors.
Good morning.
May it please the court, Ray Lapone, on behalf of the state of Tennessee. This court should affirm the judgment of the post-conviction court. The post-conviction court properly denied all the petitioner's grounds because the petitioner failed to show deficient performance and prejudice as it related to trial counsel's performance in the trial. It's interesting when petitioner's counsel wants to talk about what the post-conviction court said during this hearing. But when Your Honors look at the record, the one thing you'll see when the post-conviction court judge was evaluating all these claims is the judge kept going back to something, and you'll see it in the transcripts. Overwhelming evidence of guilt. And so when you look at prejudice first, you've got to look at the fact that both witnesses and victims in this case, Mr. Murphy and Ms. Lopez, identified this defendant as the person who came up in their house, tried to kidnap Mr. Murphy, throw him into a car at gunpoint, took his property, and shot him in the leg. The proof also showed is that Ms. Lopez saw this going on and came to the aid of her husband and shot the petitioner. When the police investigated this case, they started to go back and look in the community whether or not there were any shots fired calls in Memphis close in time to this crime. And there was only one that night. And so they went to the hospital, and who's there? The petitioner with a gunshot wound. And when they interviewed him, he gave several different accounts on how he received that gunshot wound. And interestingly, he claimed that he received it at some scene far away. But the hospital where the police interviewed him was 10 minutes from where this crime occurred. And why is that important as it relates to a post-conviction vehicle? Because the petitioner's here on a post-conviction claim. And respectfully to petitioner's counsel, a large bit of his arguments talking about all these things that should have occurred with impeachment, all these things, but barely really talked about trial counsel's performance. So turning first to this claim about testimony from Mr. Murphy in the second trial, and somehow that wasn't allowed to be vetted, the state submits respectfully the record will belies that claim. Because in fact, what the post-conviction court found was there's simply no evidence here that that ever occurred. Trial counsel said he had no recollection of that happening. The prosecutor testified at the hearing and said that never happened. And so the court's like, you have the burden by clear and convincing evidence to prove these claims, and all the court has is bare allegations and conclusory statements. Once again, bare allegations about this bribery of police officers. There's no evidence in the record of that. And to Judge Campbell, to the point in question that you made, it was vetted out. And the trial court did have a hearing. And I know when you look at this case, you'll see that it bounced around from 404B to 608 to 613. But to your question too, Judge, there's got to be a rule. That's why those rules exist, whether you're going to come under 609 or 608 or 404B. The trial judge is the gatekeeper of that. And there was simply no evidence offered that would have allowed the petitioner to go down to what the state will submit is this collateral avenue that the judge has to be a gatekeeper on in a trial. You got to start with relevance, and then you work your way to impeachment evidence. But we're here on post-conviction. And somehow petitioner's claiming that this court can ignore the overwhelming evidence of guilt because he didn't get to ask a question about a business that they owned. And to your point, Judge Campbell, they were asked about it. And they did deny it. And there was no other evidence that could have been presented to allow trial counsel to go down that avenue of impeachment in this trial. Same thing about this name. There's no evidence that he used a false name. In fact, when you look at the record, the post-conviction court correctly shut that down because the petitioner kept trying to go back and forth. What's your name? What's your name? He explained that he went by two names, and there was evidence in the record that he was also called Mike Murphy. Again, another collateral avenue that has nothing to do with showing deficient performance of trial counsel or prejudice. And if you look at this record, Your Honors, this phrase, bribery of police officers, was created by trial counsel. That was never in the record anywhere. There was no proof of that. That's what they started to call it, and it's made its way all the way from the trial court attempted to do it in direct appeal in front of this court, and now here we are on post-conviction. But the post-conviction court kept that hearing on track and simply reviewed these claims under the Strickland umbrella and forced the petitioner to stay within the bounds of trial counsel's performance, show me deficiency, show me prejudice. And look, the state gets it. The trial counsel, absolutely, if Mr. Murphy, we are not here to dispute that he had a federal drug conviction, I believe is what it was. Record will show that. And Mr. Working testified in front of the post-conviction court, told that judge, maybe I knew about it, maybe I didn't. I should have asked him. But it didn't change my trial strategy. And even on the record, what would you have done with that federal conviction, Mr. Working? Well, I would have just said, are you the same individual that was convicted of a federal drug case? And I would have been stuck with his answer. How does that level of impeachment negate 2 witness identifications and him in a hospital suffering from a gunshot wound? Prejudice was not shown, even if this court finds that was deficient performance. Lastly, just looking at all these claims, Your Honors, just bringing it back to this post-conviction vehicle, the state submits the post-conviction court properly handled this hearing. And to Judge Holloway's question, whose burden is it to prove all this? It's the petitioner's. And what burden is it when you're looking at clear and convincing evidence? To your question, Judge, they had Mr. Murphy on the stand in the post-conviction hearing. They didn't ask him any questions about these claims. He was never asked at that hearing about his name, because he got asked the question, he answered it, but they tried to go down this collateral avenue. But he was never asked, did you testify to facts other than the case on trial back when you testified? Never asked that question. Never asked the question about club visions or all these allegations of fraud. But now what we have is we have what's on the record at the hearing, and then we're back to bare allegations and conclusory statements. If Your Honors have no questions, the state will rely on its brief for any additional matters. And we ask you to affirm the post-conviction court's judgment in this case. Thank you.
All right, thank you, General Pone. Mr. Tootin?
It is interesting to hear arguments such as the evidence being overwhelming, because it still circles back to our issue of what crime, of what incident, on what day. And as far as the record not containing this issue or this issue not being raised, not only was the issue raised and supported, I'll tell you exactly in the record where it was raised. Specifically, the appellant talked about this in length about what happened. That's on volume 3. That's page 14, lines 8 to 23. Then trial counsel himself under oath talked extensively about this exact issue, about the wrong trial being testified to on volume 4. That's pages 110, starting on page 110 all the way to page 112, line 9. So not only is it in the record, it was presented at the post-conviction hearing. It was presented. And again, let's be also clear about this. In the court's order, it is not as if the court said that these weren't issues. The court acknowledged even in its ruling that there were deficiencies. The court just ultimately concluded it would not rise to the level of ineffective counsel. So it's not as if the...
Let me stop you for a second and just ask. In viewing this whole thing, I mean, talking about the evidence and what the court looked at, the bottom line is, did your client during the hearing admit that he was there and shot into the ground and got shot in the leg?
I don't want to misstate, because there were multiple statements that were made as far as how he got injured. I don't...
I mean, if I understand from the testimony, he admits being there, he admits getting shot, he admits shooting into the ground, and apparently also wrote letters to the trial judge admitting all that. Isn't that pretty strong evidence to have to get around to say that your client wasn't guilty of these offenses?
I think I don't know if is our position that we have to prove guilt or innocence as much as we have to prove was he prejudiced in such a way that it was deficient.
But don't you agree that the stronger the case, the harder it is to prove prejudice?
I do agree the stronger the case, the harder it is to prove prejudice, but I also agree that we have to be talking about the same case. And you're not allowed to bring in the wrong crime, which was grounds for a mistrial previously, and then it happened again, and then magically the remedy is we do nothing about it.
And the court found that this proof came in?
I believe the order does say that there were deficiencies made by trial counsel. I can't recall if that was a deficiency or if it was the deficiency relating to not bringing in the prior conviction. It is in the court's order, but whether it was that deficiency or the other one, I don't want to misstate, but I do know that the trial court did find deficiencies, just that the next argument was that it didn't raise to the level. But it was unrefuted based on the testimony of the appellant and trial counsel, where they laid out in detail about how that information came in. And I think even the trial counsel went a step further and said, well, the state's prosecutor at that time didn't have a reputation for necessarily being truthfulness, meaning it didn't even really surprise him that this happened. And that's again where I cited to, where I believe it was pages 110 to 112 all the way to line 9 in that, let me see which volume I just cited to, volume 4. So that's where the trial counsel gets into it extensively, but then even the appellant talks about it in volume 3, page 14, lines 8 to 23. So it is there, it's unrefuted, and it's clear and convincing. No one actually challenged that. There's nothing in the record that say you made that up or you're wrong. It's unrefuted. Thank you.
All right, thank you. All right, thank you, counsel. We'll take this case under advisement and issue a written opinion. Call the next case, please.
Victor Tresvant versus State of Tennessee.